Hello and good morning, everyone. Thank you very much for joining us for this webinar on residential tenancies this morning. On behalf of the CLA, I am delighted to welcome you to what we hope will be an informative and helpful event. My name is Flanagan. I'm a senior legal advisor here at the CLA, and I'll be chairing today's proceedings. I'm a solicitor, and I've had the joy of working for the CLA legal department on and off since 1998, conscious that might be before some of you were born. I will have had the pleasure of advising quite a few of you, I'm sure, over the years, and I'm conscious that for the rest of you, you'll currently be adjusting to the fact that I'm not actually a man. I'm Harry to everyone. Over the years, I have advised on many subjects, different areas of the law, but for the last decade or so, I have been concentrating on residential tenancies. Arguably a bit of a short straw, as it is extremely complicated, and as you will know, it changes a lot. So if you are here as a landlord or an agent and you are feeling frankly a bit exhausted by it all, you have my every sympathy. We have over 600 people registered for this event, so that confirms that it is a subject that is of importance to many of our members. Needless to say, we can only cover so much in an hour, so this webinar is designed to give you an overview of the current key compliance issues and to ensure that you know where to find the help you need from us going forward. I am delighted that I am joined today by some of our brilliant team here at the CLA. We've got Hermione Warmington, our housing advisor, who will be giving an overview on EPCs and MEs, and a bit later on the Tenant Fees Act 2019. We have Alison Provis, a regional surveyor in our Eastern region. She has a lot of experience advising residential landlords as a rural surveyor, and she will be talking through the requirements of the fairly recent electrical safety regulations. And finally, Helen Shipsey, another senior legal advisor who specialises in agricultural tenancies, many of which, of course, include a residential element. She will be joining for our Q&A session at the end of the webinar. Talking of Q&As, please do feel free to ask questions at any time during this presentation, but please use the Q&A and not the chat to ensure that we can see your questions. If for any reason we don't get a chance to answer any of your burning questions today, please do follow up with an email or a call to any of us. We just don't want anyone to go away feeling shortchanged from today. There will be a poll question later just to keep everyone involved. And final bit of housekeeping, I should remind you that today is being recorded and will be available to watch on demand on the CLA website at some stage. Right, as I said, one of the main aims is for you to know how we can help you keep up to date with the fast-moving area that is residential tenancy legislation. And the legal department and the regional advisors are here to help. I hope you all know you are entitled to free legal advice. How amazing is that? A lawyer who won't charge you anything. And I know I speak for Helen too when I say that helping you with your bespoke inquiries is our favourite part of the job. I'm sure you can imagine, if we move on to the next slide, Caroline, no 2 days are the same, but this slide sums up the general range of advice that we offer on a daily basis. Quite often we are trying to work out what rights an occupier actually has, and there's quite a few tangles out there, historic arrangements, nothing in writing, and it's never ever dull. Of course, we also regularly advise on the best way to set up new arrangements And we have a host of standard agreements that we can access for you: assured short hold tenancies, various licenses, including a service occupation agreement, and my personal favourite, not one that you'll find on the high street, the agreement to formalise a statutory tenancy under the Rent Agriculture Act 76. I just want you to know, if you take one thing away from today, please don't allow anyone into occupation of any of your properties in any capacity without first taking professional advice. Traps for the unwary abound. I, of course, also stay busy helping members understand who has to do what in any given tenancy situation, and today we'll be expanding on a lot of that: repairs, access, notices, etc. And of course, how best to regain possession when the time comes. So that's the advice side. Secondly, we try to keep you up to date with legal developments. Just flagging our guidance notes, they are available on the website, and we have a lovely new website, and we've got a slide on that coming up. And I also just wanted to show you, while we wait for that slide to come up on there's the new look website, and we have now got a dedicated residential tenancies page. So I'm not very good with computers at the best of times, so I wanted to show you exactly. You go to advice on the website, then guidance notes, and you go down to the filter there for residential tenancies, and all the notes should be in one place. Guidance notes should also, of course, get a mention in our weekly news email to members, and there will be articles in the magazine, so do please keep an eye open for those. So that's advice and legal developments. And thirdly, of course, we get involved in trying to shape the law on your behalf by lobbying and influencing. Time is short, I know, today, but I know many of you will be hoping for a bit of an update on the long-awaited Renters Reform Bill that, in short, proposes the abolition of Section 21, that's the notice-only evictions under Section 21 of the Housing Act, the reform of the other Section 8 grounds for possession, lifetime deposits, and some sort of mandatory redress for landlords. It also talks of, well, it wants to explore the merits of a landlord register and improved enforcement generally. In short, the biggest changes to the private rented sector for a generation. We've had a very constructive meeting with Eddie Hughes MP recently, the minister in charge of all these reforms, and subsequently with the government officials, who confirmed that our response that's mentioned there on the slide was guiding their thinking on the consequences of all this for rural landlords. Despite this first being a government commitment in the Queen's Speech 2019, there is still no draft bill, but there is now a promise of a white paper to further consider the issues in the spring. So we will keep you posted on that. In the meantime, of course, it never stays simple. The Levelling Up white paper last week, there were more headlines for landlords, as well as announcing that the rented homes will be required to meet the decent home standard, currently only applying to social housing. The paper also re-announced plans to end Section 21 repossessions, to consult on a national register for landlords, and to develop plans to tackle rogue landlords. As ever, there is much going on, and we will endeavour to keep you posted on all the key developments. We are fighting hard to make sure that when Section 21 is removed, its replacement will be fit for purpose and work fairly for landlords as well as tenants. So that is a whiz through how we are fighting your corner, here to help, and I'm going to hand over now to Hermione, who's going to talk about EPCs.
That's great, thanks Harry, and good morning everyone. So for the next 10 minutes, I'm going to be talking about EPCs, MEES, and the phasing out of fossil fuel heating in off-gas grid homes. So it's going to be a bit of a mix of reminding us about existing regulations, but also touching upon things that we expect to be introduced in the coming years. With the government's ambitious net zero target and buildings contributing a third of greenhouse gas emissions in England, the decarbonisation of buildings will continue to rise up the agenda. I may at times sound like I'm sharing ways to avoid complying with the legislation this morning, but this is because the system is not fit for purpose for older off-gas grid homes, not because I think decarbonising buildings isn't incredibly important. Just thought I'd put that in there at the beginning. So if we begin with looking at energy performance certificates, so most properties which have been let, sold or built since the 1st of October 2008 legally require an EPC. The reason I say most properties is because listed buildings or buildings within a conservation area may be exempt from requiring an EPC. And it is an avenue that I would suggest looking into if you have a listed building or a building within a conservation area and you are being faced with measures which you feel are inappropriate for that building. The CLA's recommended approach to listed buildings and EPCs can be found on our guidance notes, which will be mentioned at the very end of this webinar. The other thing I wanted to mention was that at the moment there is no requirement to renew an EPC once it expires after 10 years. And this is now relevant because EPCs were first introduced in 2008, so there will be a whole number of EPCs that have now expired. When that EPC needs to be renewed is on a trigger event. So that trigger event is a new letting to a new tenant or the sale of the property. There is no requirement to renew that if the same tenant stays in situ. However, having said that, there are proposals for all let homes to require an EPC. We're not sure when this will be introduced. It will be confirmed in the government consultation response, which we're still waiting for, but it's likely to probably be around 2026. So this would then bring in those homes that were let before 2008, it would bring in listed buildings and buildings within a conservation area, and it would bring in homes where the EPC has expired. So there would be a blanket requirement on let homes to all have an EPC in place. So moving on to the minimum energy efficiency standards. So the current regulations is a minimum EPC rating of band E or above. But I just wanted to mention the two criteria which means that properties fall within scope of these regulations, because quite often, especially in a rural setting, we find that actually homes don't need to comply at the moment, and it can potentially be quite useful, especially when they're designated to stop measures being installed which may not be appropriate for that building. So the first thing to check is whether it legally requires an EPC. So that's what I went through in the previous slide. Is it let or before 2008, there's no requirement for an EPC. Has the EPC expired and there's been no trigger event, or is it listed? The next thing to check is whether it's let on a relevant tenancy. So relevant tenancies cover most residential tenancies we've come across. So you've got your assured tenancy, assured short hold tenancy, your Rent Act 77 tenancy, your Rent Ag Act 76 tenancy, and an agricultural occupancy, assured agricultural occupancy. But what it doesn't include is it doesn't include holiday lets. It doesn't include farmhouses, which are let on a farm business tenancy or an Agricultural Holdings Act tenancy, and it doesn't include service occupancies. So if you meet the two criteria and you do have to comply with the minimum energy efficiency standards, but you are unable to reach band E, you will need to look at registering an exemption for MEES. So there are 6 exemptions. And I just wanted to touch upon 3 of them this morning. There is a guidance note specifically on exemptions, which can be found on our website if you want to look at all 6 of them. The first one I want to touch upon is the all improvements made exemption. And this is the exemption that you will need to register if you have spent up to the landlord's cost cap, which is currently £3,500, including VAT. And the reason I say up to the landlord's cost cap is because there's no requirement to spend more than the landlord's cost cap. So if you've spent a proportion of the £3,500 and the next cheapest measure would take you over the cost cap, there is no requirement to install that measure. So the important thing to remember with this exemption is it's only relevant improvements which count towards the landlord's cost cap. And those relevant improvements are ones which are listed on the EPC or are listed on another report which you've had done by a surveyor, for example. And all relevant improvements count towards this cost cap that have been installed since the 1st of October 2017. So it is actually worth thinking back to any improvements you've done since that date because they can count towards it. Next one I wanted to touch on is the high cost exemption. This is when the cheapest measure, so your list of recommended measures, the cheapest measure of that list is more expensive than the landlord's cost cap, so it's more than £3,500. And this one's slightly more involved because you actually have to go out and obtain 3 independent quotes to show that that measure is more than the landlord's cost cap. And the third one I wanted to mention is the third-party consent exemption. So this is where consent is required to install a measure and that consent is refused. So this might be planning consent, for example, but I think more likely, or at least what I've come across, is it's the tenant that is withholding consent. And I see this quite often with older tenants who do not want the major disturbance that comes with quite a few of these significant upgrades. And for this exemption, a landlord needs to evidence that consent is required and that that consent is withheld. And I think this exemption will become even more important when the cost cap increases, which I'm going to touch on now. Okay. So looking at the proposals for minimum energy efficiency standards. So the proposals are for the minimum EPC rating to increase from band E to band C from 2025. Although as you'll see on the slide, I've put it's actually likely to be pushed back here, and this is to reflect the delays from the pandemic. And then for existing tenancies, for the rating to be required for band C from 2028. We're also the proposals of the landlord's cost cap to increase from £3,500 to £10,000. And we have been working closely with BEIS in the run up to their consultation response. In particular, we've done quite a lot of work around a new affordability exemption and provided quite a lot of evidence to try and support a change in the EPC metric from cost to carbon. Their consultation response was supposed to be published before Christmas. It's been delayed and they aren't able to give me a date. They've just told me that it's going to be published shortly, whatever that may mean. But once it is published, we will let you know, because there's a lot of outstanding proposals that we that will be confirmed and will enable us to continue engaging. So phasing out of fossil fuel heating and off-gas grid homes. So in October last year, the government published 2 consultations which proposed to phase out fossil fuel heating in homes from 2026. There was a second consultation which proposed to phase out fossil fuel heating in non-domestic buildings from 2024, but we'll just look at the homes consultation today. So the consultation proposed using a heat pump first approach, which means that as a landlord, you would have to consider installing a heat pump before you could consider installing a different type of heating. So you'd have to show that a heat pump wasn't suitable. Now, part of the consultation was trying to understand what suitability meant, and that's something we fed back to. So that a heat pump first approach, they are also looking to work with the natural replacement cycle of the boiler. So this means that when a fossil fuel boiler breaks from 2026, you would need to replace it with a heat pump or another low carbon heating option. So, for example, if you installed an oil boiler today and you assumed that it had a 15-year lifespan, you would be looking at replacing that oil boiler with a low carbon alternative in 2037. However, the government is also looking at putting in a backstop date for when all off-gas grid fossil fuel boilers are banned. And in the consultation, they've said late 2030s. Now, that might mean 2035. They've done it before, or it might mean 2039. But there is the potential for that to happen. So it's something just to be aware of. Although we are fully supportive, as I said at the beginning, of the aim to decarbonise heat in our buildings, in our consultation responses, we argue that 2026 is just too soon to mandate the transition to low carbon heating in rural homes, as it's almost a decade sooner than urban homes are going to be required to transition. And what this approach does is it would require a relatively small number of widely differing buildings to take on all the immediate risks of an immature low carbon heating market. And these risks include high capital costs, high running costs, lack of installers, lack of skills and knowledge, especially for older buildings, and insufficiently tested reliability. And these all result in a lack of consumer confidence. But if you are interested in our other arguments, then our full consultation response can be found on our website. So that's a bit of a whiz through where we are and where we're going. And I will now pass over to my colleague Alison, who will talk about electrical safety.
That's great. Thanks ever so much, Hermione. So I'm covering electrical safety. So these regulations are relatively new. They came in 2020. And there are a few dates that at that point were important, sort of back in June and July 2020. But now the position is that from the 1st of April last year, that all tenancies that are what we call specified tenancies need to comply. The regulations were introduced via a statutory instrument, and that is available online if you're interested in the detail of that. So what is a specified tenancy? Because that seems to be the crux of the regulations as to what they apply to. So the regulations state that a specified tenancy is a tenancy which is for a term of less than 7 years, and it's the occupant's only or main residence, and that the payment of rent is made, whether that is market or not. So a specified tenancy it has to sort of comprise of all those three things. In terms of premises, that includes land, buildings, movable structures, vehicles and vessels. So it would include mobile homes and houseboats, for example, where they are the occupier's only or main residence. For the purposes of these regulations, a tenancy does also include a license to occupy. So a licensor would have the same responsibilities as a landlord, where the license fulfills the definition, i.e. granted for less than 7 years for a rent, and it's the occupier's only or main home. So fundamentally, the regulations apply to your sort of usual ASTs, short tenancies, assured tenancies, Rent Act and Rent Agriculture Act tenancies. And it can apply to the residential element of agricultural tenancies where the definitions are met. But the interaction between these regulations and ag tenancies can be quite involved. So do seek advice on that. As Harry mentioned at the beginning, Helen Shipsey, our senior legal advisor on agricultural tenancies, is on the call and is available at the Q&A for more questions on how that interaction works. So other types of occupation which you might come across in relation to the regulations, service occupancies. Do they apply? No, if no rent is payable. Holiday lets, again, no, as it's not somebody's own or main residence. If, of course, that were to change, then yes, they would come within scope of the regulations. And HMOs, yes, because it's likely that it's going to be somebody's own or main residence and rent is paid. There are a few exclusions as listed there: the shared accommodation with a landlord or landlord's family, and long leases, i.e. those over 7 years, and some others which can be found on the CLA guidance note for these regulations. So what is required under the regulations? Well, fundamentally, a landlord has a duty to ensure that the electrical safety standards are met during any period when the residential premises are occupied under a specified tenancy. That's fundamentally the bottom line. In practice, that means that the electrical installation needs to be checked at least once every 5 years as an absolute minimum. That's normally done via what's called electrical installation condition report, an EICR, but it's important to check the expiry date, as although the regulations say at least once every 5 years, an EICR, depending on the condition of the installation, could request them sooner. So the thing to look for is the next inspection date column of the report, and that will tell you the date at which you need to renew it and have it re-inspected. The regulations also require that it's carried out by a qualified person. The definition of a qualified person is somebody who is competent to undertake the inspection and testing required under the regulations and any further investigative work in accordance with those standards. In practice, there's several sort of organisations and bodies out there, but in practice, we've often seen people that are registered with the NIC EIC body and also NAPIT, NAPIT. Those are two common ones. There are some others. So if you'd like commentary on that, do get in touch. We can certainly have a look at anybody else that might be registered. Remedial work that's identified under an EICR needs to be completed within 28 days of inspection or less if required, because that could be the case. In terms of new tenancies, you're required to supply a copy of the report to all occupants before they occupy the property. And in terms of existing tenancies, to supply a copy to tenants within 28 days of the inspection being undertaken. One sort of practical tip there, which I would suggest, is when you do send out copies of reports to tenants, it's always wise to include a duplicate cover letter and ask them to sign at the bottom with a signature line and date it to say they've confirmed that they've received a copy of the report, so that you have that on record that you have provided to them and they've signed to say they've received it. With a new tenancy, when you're supplying a copy before they occupy, I'm sure everybody knows that as well as now an EICR, you also need to provide the tenants with things like a how to rent guide, an EPC, a gas certificate, if applicable. That's what's called prescribed information. So I would suggest it's prudent to include a copy of the EICR with all that information and then get the tenant to sign to confirm they've received all of that. Also, a landlord is required to keep a copy of the EICR, and where it's requested by a local authority, to provide a copy to them within 7 days of request. So moving on to enforcement, the body responsible is the local housing authority, and fines can be up to £30,000 per breach. So if there are multiple breaches, that can result in multiple fines. If a local authority believes that a landlord is in breach, then they must serve a remedial notice unless the action is urgent, which I'll come on to in a moment. Written representations are available, so where a landlord can appeal against that, and where that is the case, then the remedial notice is suspended until the local authority consider the written representations and inform the landlord of the outcome. Compliance with a remedial notice is required within 28 days or as required in the notice if less time is given. Again, a landlord can make representations within 21 days of the notice being served. If that's the case, then the local authority must respond within 7 days. If they don't, then the requirement to carry out the work is suspended until they do. And the landlord is not considered in breach of the duty if they've been able to show that all reasonable steps have been taken to comply with that duty. For example, we have seen it where a landlord has been prevented from entering by a tenant, for example, then you need to be able to show that you have taken all reasonable steps to gain entry to that property. The local authority does have the power to arrange remedial action. So if, for example, they consider that they failed to take reasonable steps to complete the remedial work identified in the report, then the local authority has the power to enter the premises and complete that. Again, that decision can be appealed by the landlord on the grounds that all reasonable steps have been taken to comply with the notice. That appeal must be made within 28 days of the notice being served by the local authority, and any costs incurred by the local authority can be recovered from the landlord and payable within 21 days of the demand. And again, there is a right of appeal against the demand for costs. Appreciate that's a lot of days and information. So that information is detailed in our guidance note. So that can be downloaded from our website. Just coming on to the urgent work, which I mentioned earlier. Urgent work is defined under the regulations as action identified in a report as being immediately necessary in order to remove the danger present and risk of injury. So where an EICR does flag urgent work is required, and where the local authority considers that the landlord is in breach of that duty, they can undertake the works. They would have to arrange that with the consent of the tenants and arrange for that to be undertaken by an authorised person. And they would have to give notice of that to the landlord and the occupiers, and the landlord does have a right of appeal against that action. Again, further information on that is in our guidance note. So if there is remedial work to be done, once it has all been done, then a further certificate, what's called an EIC, electrical installation certificate, should be issued and kept with other documentation with the other reports to show that it's a full and compliant installation. And again, a copy of that subsequent certificate should be provided to the tenant within 28 days of completion. We are aware of a member example where a member has been contacted by a local authority and they have been given a fine of £14,000 for breach of these regulations. So we are aware that the local authorities are looking at this now, and where they consider it applicable, they are applying fines. So please do be aware of that. And if you need help, please do call us and look at our guidance note. So on to the next steps. So it's important to understand the regulations, what they mean for you and your properties and your ongoing responsibilities. Next step would be to check any EICRs that you have for the expiry dates and any recommendations and remedial works within, and make sure those have been undertaken, and diarise your next inspection. We are hearing that electricians are extremely busy still in relation to both these regulations and obviously normal work anyway as a result of COVID. So as far as you can, it's wise to plan ahead to book an inspection with an electrician as soon as you can, and also have a think about when you could undertake remedial work at an opportune time, for example, any void periods or in between tenancies. But also our final point, I think Harry mentioned earlier, if you take one thing away, then it's to not let somebody in without a written agreement. I would also add the second point to take away is please keep records. We often find that that's something which members can slip up on when they are approached by a local authority. So please do keep written records of any information you give to the tenant and reports and things like that. And again, as I say, if you do give a tenant information, do enclose a cover letter for them to sign to confirm receipt to evidence that you have done that. And finally, in terms of advice and guidance, I've mentioned our guidance note, which we have on it, which is on our website. And there is also guidance on the gov.uk website published specifically in relation to these regulations. I'll now pass over to Hermione. Thank you.
Great, thanks, Alison. Let's see if I can. Great, so for the next 5 minutes, I'm going to talk about the key aspects of the Tenant Fees Act, which was introduced in 2019, so it's been around for a couple of years now. For context, the Act was introduced to limit the type and the amount of fees which letting agents and landlords could charge prospective, new and existing tenants. But as you'll see, the Act does have wider implications than just the letting of a property. So firstly, which properties does the Act apply to? So it only applies to properties which are let under an assured short hold tenancy, let under a licence, or let to students as student accommodation. So it's only those three. Other properties do not come within scope, but I thought I'd just pull out a few examples of ones that aren't in scope. So holiday lets, assured tenancies, and both of your Rent Act tenancies wouldn't need to comply with this. So what are the permitted payments? So under the Act, it lists 8 permitted payments, and it is only these payments which you or your agent can charge a tenant. And I'm going to touch on 3 of these this morning, but we do have a guidance note which goes into detail about all 8 of them, because it would be very useful to familiarise yourself with the permitted payments. So, didn't mean to do that. So firstly is rent. So the main thing to consider here is that, of course, rent is a permitted payment, but it needs to be consistent over 12 months. So the same rent in January has to be charged in August. So for example, if you had the chimney swept in January, you couldn't add an extra £60 onto January's rent and then it go back down to the agreed rent in February. That payment, if you wanted to include it in the rent, would have to be spread across all 12 months. So it needs to be consistent. Refundable deposit. So for a property which is let for a rent of less than £50,000 a year, so that's just over £4,000 a month, you are only allowed to request a maximum deposit of 5 weeks rent. For properties with a rent of more than £50,000 a year, the deposit can be taken of up to 6 weeks per rent. So either 5 or 6 weeks rent is the capped rent. Now, I'm sure quite a few of you have tenancies that were granted before the 1st of June 2019, which is when this Act became effective from, and who may have taken a deposit which was more than the 5 or 6 weeks now permitted. You don't need to refund that deposit now, but you have to refund it at the end of the tenancy or when you agree a new fixed term. Of course, you may want to get organised and refund it earlier. That may be best practice, but there's no requirement to do so. But you cannot retain that portion of the deposit for damages like you would the rest of the deposit. So it's just something to be aware of. So what payments are not permitted? Well, simply put, any payment that isn't one of the 8 payments above is not a permitted payment. So you can't charge a tenant for those. I'm just going to touch on 3 probably most relevant payments which previously you may have charged tenants and now I'm afraid you can't. So the first one is tenancy setup fees. So this may include drafting the agreement, reference checks, inventories. The tenants can't be charged for anything pretty much setting up the tenancy. So this will have to be a cost that is incurred by the landlord at the beginning. The other thing is a pet deposit. I mentioned the cap on the deposit of 5 to 6 weeks rent. That is inclusive whether they have a pet or not. You cannot charge a higher deposit than that. What we have seen happen is we've seen people slightly increase the rent to reflect the fact that they allow pets. Rent is a permitted payment. Of course, if it's an assured short hold tenancy, the rent can only be open market value. You couldn't go above that because they have a pet, but you do have the ability to potentially increase it slightly to reflect that. And the third one is third-party fees. So this is quite an important one to be aware of for landlords. So under the Act, you cannot require a tenant to pay for the services of a third party, And you also can't recharge a tenant for you using the services of a third party. And I think a really good example of this is chimney sweeping. So the government guidance does state that chimney sweeping is a prohibited payment. And the reason for this is because the tenant would need to use a third party to get the chimneys swept. But also for insurance purposes and for fire safety, as landlord, you would want the tenant to use a third party to sweep the chimney. Another example is gutter clearance. So you can ask the tenant to clear the gutter if it's reasonable that they could clear the gutter without needing to use a third party, but you can't require them to use a third party. So the tenancy agreement can say the tenant is required to clear the gutters, but it couldn't say the tenant is required to clear the gutters using a professional service. If as a landlord you would like it done by a third party, that is something that you would have to do and pay for yourself. You couldn't use a third party to clear the gutters and then recharge the tenant. You would just have to incur that cost. A bit like I mentioned with the pets, rent is a permitted payment. So what we have seen is landlords looking at the additional costs they've incurred as a result of the Tenant Fees Act and potentially spreading the increase across the 12 months for a slightly increased rent. The important thing is it's not separated out. And as I mentioned before, it's consistent across the 12 months. The reason why the Tenant Fees Act is important is because if you're in breach of the Tenant Fees Act, then you can't serve a valid Section 21 notice. So it is something that might be useful to go back across your portfolio and just check that how you manage your properties and the payments that you require tenants to pay are all permitted under the Act. And I will now pass over to Harry.
So sorry, I am here now. The Housing Health and Safety Rating System, I just wanted to flag this up. It has been in existence since it was introduced by the Housing Act 2004 and should have been implemented, was implemented in law since 2008, but has been relatively little used. It is the system by which local authority environmental health officers should be assessing housing conditions in their area. It really, due to lack of resources at local authority level, has been very, very rarely enforced, but we have seen a slight upturn in inquiries, and we're wondering if it's starting to be enforced more widely. So we are going to have a poll, as we would be very interested to know the extent to which any of you have come across this in practice, either personally or your clients. It's not a very scientific poll, it was just to get a feel for the room. So the question is, have you or your clients experienced an initial letter, an inspection by an EHO, and or any enforcement activity such as a hazard awareness notice, improvements notice? There are more severe ones, they're the most common, under the HHSRS. And the choice is fairly simple: yes, no, or don't know. And we would love you just to fill that in, and the results will show up on the screen. I understand because there's hundreds and hundreds of you, that could take a while. So I would just just go on to say that it's interesting. We're concerned that some of these 29 hazard profiles and the tick box exercise that accompanies these inspections not always wildly appropriate in older properties, traditional heritage constructions. So we hear tales, one or two horror stories of beams being too low and banisters inappropriate. And we just are keen to monitor it because we want to make sure that it is applied appropriately in some of the contexts that we operate in. The government guidance on this, we're going to pop a link into the chat. It should be coming up there. If you haven't come across it and you want to find out more, that's probably your starting point. There are two other extraordinarily long bits of government guidance on this, but that's the one to start with. I should say that I think the government has realised that the guidance is completely impenetrable in places and are currently reviewing it. And I've been asked to have a look at some of the guidance as it emerges. So we will be keeping an eye on it. And I think the advice that I can give you, if you are inspected or if you get a letter and it's got Housing Act 2004 on the top of it, HHSRS, I would say don't sort of put it in the pile and hope it goes away. Do engage positively with it at an early stage. The inspectors are meant to make informal approaches before they move to any sort of nasty notices. So it's really important to sort of get them on side and to be as cooperative as possible, I think, tactically in the early stages. So that was just to flag that up because it's something that we are is a little bit more on our radar to keep an eye on. So I think while we wait for the poll to come up, there we go. I hope you can all see that. 14% of you have come across it in some shape or form. 82% haven't at all, and 5% don't know. That is very, very interesting. Thank you. It sort of confirms our suspicion. It's not sort of spreading like wildfire. But I should just flag up, since a piece of legislation in 2016, the Housing and Planning Act, local authorities can now keep the penalty fines that they might charge as a result of breach of this legislation in an attempt to become a bit more self-financing, which is why we suspect that enforcement will gradually start to increase. So something to be aware of. And yeah, please do feed in your experience to us because it helps us shape guidance for our members. On that, we do have a very elderly guidance note on our website about all of this, but it could do with a refresh, but we're waiting to see what the government are doing with their guidance before we embark on that. Right, so that is the Housing Health and Safety Rating System. And I think now we will move to your questions. We'll ask Helen to join us and the speakers to come back. Just a reminder that to use the Q&A at the bottom of your screen, not the chat. We have had heaps of wonderful, wonderful questions. So we will crack on with those. Gosh, they're coming in thick and fast. I think we'll start with one for Alison. I have a tenant on a fixed term tenancy which is about to end and move on to a rolling periodic tenancy. Is this considered a new tenancy for the purposes of the electrical safety regs, Alison?
So that sort of issue was between the June 2020 and the April 2021 transition period. So now from the 1st of April last year, 2021, it applies to all existing tenancies. The position is now that all tenancies, regardless of when they started, should now be compliant with the regulations.
Brilliant, thank you. I have got one here that's come in for Hermione. Where a cottage let under an AHA, Agricultural Holdings Act, is sublet on an AST, do the EPC or MEES regulations apply?
Okay, so an EPC will apply if that sublet farm cottage was let post 2008. In terms of the minimum energy efficiency standards, it's the direct landlord who is responsible for meeting this legislation. So in this situation, the farm tenant would be responsible for obtaining an EPC and or complying with MEES. Now you would want to look at the farm tenant's responsible. The farm tenant would want to look at what tenancy agreement it was let on, because I know for a lot of AHAs, they would be let to farm workers under a service occupancy and therefore would fall outside of the requirement for MEES. But yes, the direct landlord, farm tenant.
Still on, thank you, Hermione. Still on AHAs, one for Helen. The question is, we have a number of AHA non-model clause tenancies where the tenant is responsible for electrical repair. Who is responsible for testing the electrical safety for the farmhouse? Good question.
Yes, thank you for that. As always, starting point is the tenancy agreement to assess exactly what regulations, what contractual terms there are, and then whether any of the regulations and the model clauses might apply, albeit that it's a non-model clause tenancy. There are instances where, if it's really clear that the tenant is responsible for electrical repair, that he may well be responsible for that. But actually getting the testing done, that will be the landlord. That overrides, that sits on top of all these obligations. The difficulties then are whether there's any remedial work. Of course, it might be a question of replacement, not repair. And there's that very tight time scale. And we're watching closely to see whether this is going to cause, inevitably, there will be instances where landlord and tenant don't agree on what their obligations are. But always send in an inquiry, if you'd like, an assessment of the particular circumstances. Thank you.
Thank you, Helen. We've had a couple of questions about gas safety, and I've replied to one in the chat, but just to say, we've got a very comprehensive guidance note on gas safety regulations, which of course have been in existence for a long time. And the link to that guidance note is coming up at the end of this presentation. Another one for Hermione. If I install energy efficiency measures now, will they count towards the increased landlord's cost cap of £10,000? We've had a few on these, Hermione, so
okay, so yeah, so good question. The answer is we don't know, but probably not. At the moment, we're waiting for the government's response, but it is likely, or their proposal at the moment is for improvements made from next year, so April 2023, will then count towards the increased cost cap of £10,000. So it might be, if you can wait to do some bigger improvements, it may be useful to wait until we know when that money will count towards the cost cap. When you registered that exemption for the landlord's cost cap, that exemption lasts 5 years. Now, on the 5th year, on the expiry of that exemption, you will need to register another exemption or bring the property up to the minimum rating. So you may be required to spend another £10,000 in 5 years' time. This is something that we are making very, very aware to government and trying to push back against, because we appreciate it is just unaffordable for some rural homes to have to continually spend that amount of money within a system that doesn't work. So we are trying to rural proof it, but that is the regulations as we see them coming in.
Thank you, Hermione. I've had one or two on tax, and I'm going to say, so sorry, not going to answer those because we've got a brilliant tax department, the CLA, who would be happy to answer them. So don't hesitate to get in touch with those. Another question asking me for my best guess on when Section 21 evictions will, well, when I assume they're asking when that law will change. And I'm afraid, no idea. It's been pushed back so many times. I think there are slight issues about parliamentary time possibly, but all we know is that it's going to be not even a draft bill is promised, but a white paper in the spring is when we're expecting a white paper. So there will be further consultation, and how long it takes, frankly, is anyone's guess. What we do expect from, if the original consultation is anything to go by, is that any removal of Section 21, those changes will apply to the new tenancies created after the change in legislation. So we expect, from what we know so up till now, that Section 21 would be available still for pre-existing ASTs. Also, just to say, the government did indicate that there would be a run-in of at least 6 months for everyone to get their heads around any changes. So we are a long way off changes. So I hope that's helpful. Next question. Oh, one for Alison. A couple have come in touching on this. My EICRs were undertaken less than 5 years ago, but before the 18th edition of the wiring regulations came into force. Is my EICR still valid? Alison?
Yeah, that's a really good question. So the regulations require that they have to meet the electrical safety standards, which at the moment is the 18th edition wiring regulations. They came into force on the 1st of January 2019. So if you've had an EICR done since the 1st of January 2019, then that will be undertaken in relation to the 18th edition. So you should be fine, subject to any remedial work that they needed doing. Prior to that, if it's still within the 5 years, but prior to the 1st of January 2019, it doesn't necessarily mean you have to go out and get a new one. There's a section on this in our guidance note, so please do download it if or call us if this is your question. But fundamentally, the position is that a landlord would need to go back to their electrician to look over the certificate and the installation, and likely revisit, I would suggest, given obviously that the electricians won't really recall every installation, and cross-reference with the new 18th edition regulations and see whether there are any remedial works needed as a result. Obviously not overly satisfactory, but that is the guidance that the government have published, and that is available on gov.uk. We have commented on it on our guidance note. So yeah, if you need help on that, do give us a call.
Thank you, Alison. Now we've got some really good questions flooding in on the Tenant Fees Act. Hermione, do you want to answer the one on septic tanks? If you read out that question, and I wonder if we could combine it with, there's a couple there. Is it possible for payments to be paid as a service charge on boiler services, chimney sweeps, etc., etc.? Can I? And there's also one actually on gardening services, similar one. So could you address those, Hermione? Thank you.
I can. Firstly, I should apologise. I missed out a paragraph in my presentation about utilities, which are a permitted payment. So utilities, this would include gas, electricity, water, and things related to the provision of those utilities. They are a permitted payment. So emptying a septic tank is a permitted payment. But what you can't do is you can't overcharge for emptying the septic tank. You can't make money off it. It has to be the actual cost of doing it. So utilities permitted payment. So the questions in there about emptying the septic tank, you can either ask your tenant to do that themselves, or you can do it and recharge your tenant. Now, what you can't do is you can't charge for third parties to undertake other things that isn't a utility. So the gardening services was a really good question. Unfortunately, you can't recharge your tenant for using, even if it's your own gardening services. What you can do is you can require them to maintain the garden in their tenancy agreement. You just can't require them to use a third party. And that's the same with gutter clearancing, boiler services. Now, you can't separate out those payments and charge it as a service charge. What you can do, and what we will see, I think, the industry doing to react to this legislation, is to for those charges to form part of the rent, spread over the 12 months to reflect the increase in costs and management time that you will incur as a landlord. But no, they can't be separated out, and that is quite an important point. They shouldn't even be separated out within the rent. They are just the rent.
Brilliant, Hermione. Now, apologies everyone, I'm seeing on my clock it's 11:01, but we have got so many good questions. I am being told by those in control that we're allowed 4 more minutes. So we'll do a couple more questions before we wrap up. But obviously, feel free to go if you need to. Now, I had a very good question from Alice. Helen, I think this is probably for you and or Hermione. Do we have any guidance on the interaction and responsibilities between works required under an EPC and the AHA model clauses?
No, thank you. It is a great question, but I have chosen not to come up with a one guidance note suits all because of the intricacies of these scenarios. There are too many pieces of legislation that might impact on the on the answer, and so it is much better to send in a tenancy agreement with specific questions to get your bespoke response. Thank you.
How brilliant is that? Being able to do that for free. Now, another one, again, Hermione, Helen, the question is, I think you said that FBT properties are excluded from ME's EPC rules. Is that still true for new FBTs?
I did put something in the chat, or a written response on this. So FBTs are not EPCs. FBTs are not exempt from EPCs. You might well need to have an EPC in place, and then for the farmhouse, when it comes to MEs, the farmhouse is under a commercial letting, but is not impacted by MEs because it's a residential dwelling. And then with domestic MEs, the farmhouse is not a relevant tenancy for those purposes. So at the moment, the farmhouse wouldn't be covered by MEs. Hermione can say anything to gainsay that if she wants, but
no, that's absolutely right. I think the government sort of forgot about farmhouses. I imagine they'll be swept up at some point in the future, but for now there is no legal requirement to meet a minimum standard.
So such are the legal intricacies that we happily spend our days trying to untangle for you here at the CLA. I'm conscious of time, so I think we will have to sadly leave the questions. There's still some brilliant ones there. Please do follow up with us if you would like answers to any of your questions. And we'll just move on to our final slide, please, which just to give you some going home presents from today. They are a list of just some of the guidance notes that are touched on today. The gas safety one is there. Just a reminder, if you go onto the website and press advice and then guidance notes, you should be able to find them all under residential tenancies. The webinar, I'm told, will be available as a recording on the CLA website as well in due course, and we would love feedback from you on how we can improve this, anything else you would like us to do for you. And it just remains for me to thank you very much for joining us, to thank our presenters, and of course the wonderful people behind the scenes without whom none of this could possibly happen. Thank